Chapter 5, Office Inspections and Disciplinary Process. The broker's office is more than likely going to have a routine audit at some point. It's a very simplistic audit. The auditor is going to come in, they're going to check for the office entrance sign. They're going to check for all the license that the broker has with that brokerage. They're going to check for agency disclosures if in fact the brokerage is giving agency disclosures. They'll check the escrow account, but only if the broker is actually holding escrow. Remember that if a title company or an attorney is holding escrow, the broker will not be holding escrow, therefore is not going to have an audit. The audit itself will only occur if the broker is actually holding escrow, and that is if it's in a commercial bank, a savings and loan, or a credit union. Remember that if the broker places escrow in a title company or with an attorney, there's not going to be an audit. The auditor only wants to audit for those accounts that the broker actually has signature over. And they're going to go through the entire process. They're going to look at all the books. They're going to look at all the deposit slips, everything that's necessary. I think the important thing here, though, is that the investigative findings, that when the audit is finally over with, at that point, if there's any discrepancies, that's when the question will be asked, what about this? What about that? And as long as the broker can explain what these discrepancies are, everything seems to be okay. It's when we have a shortage or an overage that the broker can't explain that we have a problem. And then the question is, what happens? Well, at that point, the auditor is going to write a complaint and file it with the Department of Business and Professional Regulation. And then the next step is that once that complaint is filed, then it goes through the disciplinary process. So what I want to do right now with you is to go through the entire disciplinary process. I think it's important to note that Florida Statute 120 allows everybody to have a hearing at some point if there's some type of complaint filed. I'm going to just go quickly over the various aspects or the various components of the disciplinary process. There's going to be a complaint, an investigation, probable cause panel, a formal complaint, a hearing, a final order, and an appeal. Those are the steps that you're going to have to go through. So let me just start out by going over one at a time. First, there is the complaint. To begin with, if it is the routine audit, the complaint obviously is coming from the DBPR. But under all other conditions, it might be the general public who's making the complaint. So therefore, the complaint needs to be in writing and signed by the complainant regardless. It also needs to be legally sufficient. And when I say legally sufficient, what I mean is that Florida law or some type of law needs to or should have been violated. If it's not legally sufficient, I'll give you a good example. If somebody files a complaint against me and says David Collins is a dirty rat. Well, I may be a dirty rat, but that may not be illegal. So it has to be legally sufficient. Once it's discovered that it is legally sufficient, then there's going to be an investigation to gather information. And the investigator will be coming out of the DBPR, will go into the field, collect contracts, collect all kind of documents, question people, get as much as they can to build a case basically. When it's over with, the investigator is going to write an investigative report. That investigative report then is going to be turned over to the Florida Real Estate Commission and also the attorneys at the Division of Real Estate. Once the Real Estate Commission gets the investigative report, the chairperson of the commission is going to appoint 2 members to a probable cause panel. Now let me explain to you who the 2 members of probable cause are. At least one has to be a current member of the Florida Real Estate Commission, and there has to be at least one licensed member. Right now the Real Estate Commission is drawing off of past members to set on probable cause. Once the probable cause panel gets this information, they're going to determine if probable cause exists or does not exist. If probable cause does exist, based on the legally sufficient information that the attorneys at the division sent down, the next thing that's going to happen is they're going to send that probable cause report back to the Division of Real Estate Attorneys to write a formal complaint. That formal complaint is an outline of charges. And at that point, the licensee involved will become the respondent. Therefore, when the formal complaint comes down, that respondent or the licensee involved has 20 days to respond to the complaint. They're going to get a letter in the mail by certified mail, and it's going to say, I agree or I don't agree. Check one, sign it, and send it in. If they agree with the charges and say I did it, need to figure something out here, there's going to be an informal conference. Oftentimes, the attorneys at the division will contact that licensee. They'll try to work out some type of stipulation. That's like a plea bargain. If they can't work out a plea bargain or a stipulation, then you have the right to a hearing and go ahead and give your side of the case. You'll be heard before the commission, minus those members that were on probable cause. If you disagree with the charges and say simply, I didn't do it, that wasn't me, whatever it might be, you have a right to a formal hearing. And that formal hearing is going to be heard before an administrative law judge. It's like Perry Mason. They'll subpoena witnesses, they'll subpoena documents. It's just like a regular trial. Once the formal hearing is over, the administrative law judge is going to write a recommended order. Now that recommended order is only that person's opinion. 10 days after that recommended order is written and submitted to the division and to the Real Estate Commission, the respondent and the division of real estate has the right to challenge it. It's called a written exception. And they've got 10 days to file a written exception challenging that recommended order by the law judge. Regardless, it will go before the FREC, and you'll have one more shot at a hearing. Now, if you don't challenge the recommended order, it's probably going to be rubber stamped and become a final order. But if you want to be heard that final time, you can certainly be heard. You'll have your chance. At the end of the day, the Florida Real Estate Commission is going to hand down a final order, and that final order will not become effective for 30 days. Now, I think the interesting thing about this whole thing is that most violations of Florida Statute 475 are misdemeanors of the second degree. You do have some violations of first degree misdemeanor. Chances are you'll be able to continue to practice real estate during the entire hearing process, even 30 days after the final order. That final order won't take effect. So you can continue to practice, and there's only one exception that I've heard of, and I've not really seen a lot of it. If the Division of Real Estate or the Real Estate Commission believe that you could still be a danger to the public, they can ask a judge to issue a summary suspension that would put you out of business during the hearing process. After the final order comes down, if you still don't feel satisfaction, if you think it was wrong, you do have a right to appeal it to the district courts of appeal. Now, during that time, during that 30-day time period, you might also want to file something called a supersedious. What supersedious is going to do is it's a stay of execution, or better yet, it's a stay of the final order. In other words, you're going to put it off until your appeal is over with. But remember, once it goes through the district courts of appeal, and it's heard by those judges, then it's over with. Whatever their decision is will be the final decision. Some of the penalties that the Florida Real Estate Commission can impose, and once again I have to caution us that the Real Estate Commission can only discipline a licensee. The Real Estate Commission cannot discipline somebody that's unlicensed. Currently, the practice of real estate without a license, the unlicensed practice of real estate, is a third-degree felony. The Real Estate Commission cannot discipline those individuals, but the State Attorney's Office can. So what can the Florida Real Estate Commission do? They can deny the license application. They can refuse to renew your license. They can revoke your license permanently. They can suspend your license up to 10 years. They can fine you up to $5,000 per charge, place your license on probation, also send a letter of reprimand. Now let me make a comment about the notice of non-compliance. This is important. The notice of non-compliance is typically found when a routine audit occurs, where something in the broker's office that's minor infraction, such as the sign's not right, maybe there's not enough license there to meet the how many licenses you actually have on record that are placed with the broker. Any number of things that are simply where the public is not in harm's way. They'll issue a notice of non-compliance. They'll give the broker 15 days to correct it, and as long as the broker corrects it within that 15-day time period, nothing will be said. If it's not corrected, then there will be issues. Some of the judicial remedies that we've already talked about, as I said, most things are going to be a second-degree misdemeanor, which carries the penalty of up to a $500 fine and or up to 60 days in a county jail. There are some things, however, that are a first-degree misdemeanor, which carries a penalty of up to a $1,000 fine and or up to 1 year in a county jail. Violation of the rental information rules is one of those things that's a misdemeanor of the first degree. Now, there could also be some civil penalties that are imposed. You could even lose your commission. And let me say this also, that the Department of Business and Professional Regulation, because you are regulated under Florida Statute 455 as well as Chapter 475, DBPR can fine you up to $5,000 per charge also. The Real Estate Recovery Fund is money that's set up to pay back individuals that have been financially damaged by a real estate licensee, some type of fraud. And the way this has to work is that the individual first has to get a judgment against the individual licensee, not a corporation. And they have to do an asset search to prove that the licensee does not have personal assets to pay for the judgment. The recovery fund will only pay for compensatory damage and not punitive. Compensatory is actual damage. Punitive is punishment, such as treble damages, which means 3 times the actual loss. So the Real Estate Recovery Fund will pay for any kind of compensatory damage up to $50,000 for a single judgment and $150,000 for multiple judgments. Now, if money is taken from the recovery fund because of a licensee involved in this, the license of the licensee will be suspended indefinitely until the money is repaid plus interest. Now, there's only going to be one exception. Remember, we talked about the escrow disbursement order. When a broker has a dispute, they go to the commission and say, tell me what to do. Tell me what to do with this money. If the commission says, give the money to the buyer, the broker writes the buyer a check. Then all of a sudden, the seller takes it to court and a judge says, give the money to the seller. Well, unfortunately, the money's already been given. The judge will then say, seller, you have the right to go to the recovery fund to get your deposit back. If that's the case and money's taken from the recovery fund, the broker's license will not be in jeopardy. And that's all we have for Chapter 5. What I'd like to do right now is the summary for Chapter 5. A routine office inspection includes the office entrance sign, license and registrations, and agency disclosures. At the end of the audit, a complaint may be filed if there are serious discrepancies. Notice of non-compliant will be issued for minor discrepancies with a 15-day correction period. The disciplinary process includes the complaint, an investigation, probable cause panel, formal complaint, a hearing, and a final order. And ultimately, if the person wants to appeal, they certainly can. The administrative penalties include suspension up to 10 years, revocation, which is permanent. The Florida Real Estate Commission can fine up to $5,000. The Department of Business and Professional Regulation can also fine up to $5,000. Probation, a letter of reprimand, and to deny the license application. Judicial remedies include a second-degree misdemeanor, which is a fine of up to $500 and or up to 60 days in jail. And there's also a first-degree misdemeanor, which is up to a $1,000 fine and or up to 1 year in a county jail. There can also be civil penalties, which means that you can lose a commission. The Real Estate Recovery Fund is to pay compensatory damage only to individuals that have been financially damaged by a real estate licensee in a real estate transaction. Authorized payouts of up to $50,000 for a single judgment and up to $150,000 for multiple judgments. The license of the guilty licensee will be suspended indefinitely until the money is repaid plus interest. The only exception is if the broker follows a lawful escrow disbursement order issued by the Florida Real Estate Commission. And that's the end of Chapter 5's summary.